James Garner, is James Garner here?
I'm here.
In today's case, we are walking straight into one of those classic sovereign citizen showdowns where confidence meets consequences. The defendant, James Garner, doesn't just stroll into court. He enters wearing a hat, a scarf, and an attitude that says the rules apply to everyone but him. Judge Perkins, however, is the absolute last judge you want to test on jurisdiction fairy tales and YouTube lawyer arguments. Over the next several minutes, you're going to watch a slow-motion car crash of legal misunderstandings collide directly with courtroom reality. Garner isn't facing just one or two charges. We're talking stack cases, suspended license issues, improper plates, expired licenses, and unpaid fines. But the twist? None of these are the reason he ends up in jail today. Instead, he talks himself into a 30-day contempt sentence by refusing to answer basic questions and treating procedure like a debate club. As we move through this hearing, pay close attention to the public defender's reactions. Judge Perkins' patience meter slowly draining, and the moment Garner crosses the line from misguided to contemptible. Buckle up, this one turns fast.
Good morning to you, sir.
Good morning.
What is your middle name? Can you remove your hat, please? And your scarf. What is your middle name, Mr. Garner?
Errol.
Earl?
No.
He's on the 130 docket, Your Honor, I believe.
James Garner, Earl Garner. James E-R-R-O-L Garner, right?
Yes.
You are on the 130 docket.
If you want, Your Honor, I can give House Counsel an offer right now. She can report it to him.
On James Garner, do you see all the cases he has?
I see just the 4 that are on the docket, or 5.
Yes.
He's got more?
He's got plenty more.
Okay. You want me to come down, review, and do a global offer?
If you could, please.
Okay, I'm on my way down.
Mr. Garner, do you want to offer on these or do you want to go to trial? Okay.
At this point, something really important becomes clear. This isn't a one-time mistake or a minor paperwork hiccup. Garner has accumulated case after case, ticket after ticket, until the system finally said, "You're coming to court." What you're seeing is a pattern. Suspended licenses, no insurance, improper plates, all things that exist to protect other drivers on the road. Sovereign citizens love to argue abstract jurisdiction while overlooking the fact that traffic laws exist because 2-ton metal vehicles moving at speed are dangerous. Notice also how calmly the court lists everything. There's no drama from the judge. No insults. Just a mountain of legal reality being read out loud. This is where most defendants feel the weight of the situation and start working with their attorney. Garner, however, is already mentally preparing to argue law school concepts he found online to the judge who actually went to law school.
Versus James Earl Garner, case number SP 1100435, counts 1, 2, and 3. SP 11695. Those are driving license expired, misdemeanor, no insurance, misdemeanor. Thank you. And an improper plate misdemeanor, all of them punishable by maximum possible penalty of 93 days in jail and or $500 in fines. SP 1169507, counts 1 and counts 2, expired license and no insurance misdemeanor, both punishable by 93 days in jail and or $500 in fines. SP 1169521, same improper plates, same punishment, $500 in 93 days in jail and or $500 in fines, maximum possible penalty. SP 1223079, driver license suspended. SP 127-37681, SP 139-27512. Three of those tickets are drive, all punishable by 93 days in jail and or $500 in fines. SP 1547006 counts 1, counts 2, and counts 3. Those are civil infractions. SP 1547407 counts 1 and counts 2. Count 1 being a driver while license suspended repeat offender. This one is in warrant status, probably an old case that he didn't pay. SP 800104 counts 1 and counts 2. 1 being an unregistered untitled. He owes $1,194 on that. And SP and count 2 of that is a drove while license improper. It looks like he has a $114 fine on that. State of Michigan versus James Earl Garner, case number SX 36268561. That is a drove while license expired. And that will be $500 maximum possible penalty.
On behalf of Mr. Garner, please state your name for the record.
First off, I do have a couple.
You got to state your name first. You got to state your name first.
No,
Let's start there.
Wait a minute, Ms. Harris. Wait a minute, Ms. Harris. I think Mr. Garner is going to represent himself. Am I correct, Mr. Garner?
I'm representing myself in what? I mean,
Self-representation moment. Every experienced courtroom viewer knows this is the point where things usually take a turn. Defendants who represent themselves often believe it gives them more control, but in reality, it removes the only person in the room whose job is literally to stop them from getting in deeper trouble. The public defender immediately recognizes what's happening because she has seen this movie before, someone convinced that legal buzzwords equal legal strategy. The irony? The court is actually giving him options, explaining consequences, and trying to protect his rights. But his focus isn't on outcomes, it's on ideology. Once a defendant becomes more invested in proving a point about the system than resolving their own case, contempt becomes almost inevitable.
confused about what's actually going on. First off, who's alleging these charges? That's what I'm curious about.
State of Michigan, City of Detroit.
Okay, well, if that's the case, there's a common law principle which states that for there to be a crime, there must be a victim. Corpus delicti. The state cannot be the injured party. And in the absence of a victim, there can be no crime.
We want to do it.
Withdrawing my name from the record on that one. Thank you.
I know. How do you want to proceed, Mr. Garner? You set the matter. I'll enter a not guilty plea on his behalf. Give him a $0 bond. Either set the matter for trial, or I'll wait for the city to give you an offer. What do you want to do?
Well, the court hasn't even established jurisdiction. I mean, in order for jurisdiction, the jurisdiction has to be established first, and there's no jurisdiction established. And once jurisdiction is challenged, that must be settled before charges.
This is the classic Sovereign Citizen greatest hit album, No Victim, No Crime. It sounds powerful until you realize traffic offenses fall under public safety laws, not personal injury disputes. The victim isn't a single person. It's the public who is put at risk when uninsured, unlicensed drivers operate vehicles. Courts across the country have rejected this argument repeatedly, but it lives on in online forums and YouTube lectures where nobody goes to jail afterward. Judge Perkins doesn't even need to debate philosophy here. His job isn't to convince Ghana, it's to run a courtroom. And that's where sovereign citizen ideology always collides with reality. Belief doesn't override jurisdiction, and refusing to acknowledge the system doesn't make it dissipate.
All right, do you want to put that in a motion, sir?
As far as I'm concerned, any and all charges must be dismissed because there is no complaining witness. And the state cannot be.
I'm not gonna listen. If that's your motion, I'm gonna deny the motion. Okay, So all we're gonna do now, we're not gonna keep going back and forth. Either you take an offer or you set the matter for trial. Which one do you want?
Respectfully, in order for this to continue, there must be a complaining witness, and the state cannot be a complaining witness. Now, if I'm entitled to a fair trial, the law states there must be a victim. I'm just requesting, who is the victim? Who did I injure?
The citizens of the city of Detroit and the state of Michigan are the victims.
The state cannot be a victim. And if that's the case,
I said the citizens of the city of Detroit and the state of Michigan are the victims.
if that's the case,
Mr. Garner, Mr. Garner, can we just go into a breakout room and then maybe I can give you a little bit of advice to assist you with moving forward? Would you be agreeable to that?
Sure.
Right here is the crucial fork in the road. The judge is asking a simple procedural question. Do you want a plea offer or do you want a trial? That's it. 2 doors. Pick one. But Garner refuses to step through either because he wants to debate the existence of the building instead. Judges will usually tolerate some confusion, even some stubbornness, but what they cannot allow is refusal to participate in the process entirely. That's when the court loses function. You can also feel the judge's patience thinning. He repeats options. He explains consequences. He even entertains motions. But Garner keeps circling back to jurisdiction arguments that have failed in every courtroom they've ever been used in. Each missed answer brings him closer to contempt.
He's ready, Your Honor. He's representing himself.
Let's go back on the record with Garner. What do you want to do, Mr. Garner? Do you want a trial date or you want an offer? Those are really your only 2 options.
Okay, since we are on the record, all I'm asking for is the
Okay, one last time. Now listen, here's how it's gonna go from this point on. If you don't answer the question that I asked specifically, then I'm gonna hold you in contempt of court, and we're gonna move from that point.
This is the red flashing sign moment. When a judge says one last time, they are no longer negotiating. They are drawing a legal boundary. At this point, the outcome is entirely in Garner's hands. He doesn't need legal knowledge to avoid jail. He just needs to answer the question asked. Instead, he keeps trying to redirect the conversation back to his talking points. Contempt of court isn't about disagreement. You are allowed to argue, file motions, challenge evidence. All of that is normal. Contempt comes when you refuse to follow the court's basic instructions, making it impossible to proceed. Garner is no longer defending himself. He's actively preventing the court from functioning, and that's the line he's about to cross.
You're telling me,
Mr. Garner, we're not going to have a conversation. Stop, sir. Stop, sir. Now, that's the last time I'm going to ask you to.
On the law. Is that what I'm hearing?
All right.
I'm asking.
I'm going to hold Mr. Garner in contempt of court. He is directly violating the court's order. I've asked him repeatedly to not interfere or add any extra commentary to this case. I've given him ample time to answer the court's question, and he continues to refuse to do so. So now I'm going to hold you in contempt, and I'm going to sentence you to 30 days Wayne County Jail. No early release.
So that means that the court is just going to violate my rights because I'm defending myself? Is that what I'm hearing?
30 days, Wayne County Jail, no early release. That'll give you some chance and some time to read up on your rights, okay? Fill out the contempt papers, Madam. So I'm going to order you to turn yourself in today, Mr. Garner, to start that jail time, okay?
So I have a question.
I'm not answering any more of your questions. Turn yourself into the Wayne County Jail today.
So the court is going to be in direct violation of my rights in the law. Is that where we're standing?
If that's how you feel. Have a good day, sir. Make your special appearance to the Wayne County Jail. I told you that the last time.